Hafaday, good morning, everyone. The Committee on Health, Land, Justice, and Culture is now called to order. Today's Thursday, February 25, 2021. The time is 9:04 a.m. Notices for this public hearing were disseminated via email to all senators and all main media broadcasting outlets on Thursday, February 18, and again on Tuesday, February 23rd, 2021. The notice was also published in the Guam Daily Post on Thursday, February 18 and Tuesday, February 23rd, 2021. The Zoom meetings hosted by the legislature's MIS staff, and I thank them for their assistance. The host of this hearing will mute all Zoom participants until called upon by the chair. Individuals testifying shall first be recognized by the chair before speaking and begin by stating their name for record-keeping purposes. We have two agenda items today. Bill number 8-36 COR, which is relative to exempting individuals convicted of first or second degree criminals sexual conduct from sentencing reductions of the Justice Safety Valve Act. The second item on our agenda is Bill number 45-36 COR. It's an act to amend it's relative to addressing mandatory minimum sentences for repeat sexual offenders. Bill number 44-36 COR is relative to prohibiting plea deals without reasonable proof of victim notification. I'd like to acknowledge this morning the presence of my colleagues, beginning with Senator Jose Pedo Terlaje, Buenas, Senator Anthony Ada, Senator Chris Duenas, and Senator Untitled. Good morning, colleagues. Thank you for being here. All right, we'll proceed directly to our first item on the agenda, and that is Bill number 8-36 COR. It is introduced by V. Anthony Ada. It is an act to add a new section 80.39.2D to Article 2, Chapter 80, Title 9, Guam Code Annotated, relative to exempting individuals convicted of first or second degree criminal sexual conduct from sentencing reductions of the Justice Safety Valve Act. I'll now invite the sponsor, Senator Ada, to introduce the bill.
Thank you, Madam Chair, Madam Speaker, for having the hearing on this bill today. To my colleagues, thank you for being here, the AG's office, and all those present on this Zoom and listening in. Bill 8-36 COR does one thing, Madam Speaker. It removes the ability of judges to sentence those convicted of first or second degree criminal sexual conduct to less than the mandatory minimum sentence under the Justice Safety Valve Act. This means that a judge can sentence a defendant who was convicted of first or second degree criminal sexual conduct under the Justice Safety Valve Act to probation or a minimum term of incarceration. Madam Speaker, originally the minimum sentence for first degree criminal sexual conduct was 15 years and 5 years for second degree criminal sexual conduct. Both laws stated that violators were not eligible for parole or first-time offender treatments. The Justice Safety Valve Act, which became law on May 7, 2015, superseded these sentencing guidelines. Over the last 3 years, 100% of the crimes charged as first or second degree criminal sexual conduct have been committed against victims under the age of 16. Madam Speaker, unfortunately, child sexual assault has a recidivism rate all too high. On Guam, not too long ago, we read in horror an article about a twice convicted registered sex offender who abducted and sexually assaulted a 10-year-old girl as she waited for her school bus. I understand the importance of the justice system to make plea deals, to get convictions, and spare the victims the trauma of testifying at trial. In criminal sexual conduct cases, the plea deal or sentence reduction should be 15 years instead of 25 to life, but not 2 to 3 years. Madam Speaker, I ask that you report this bill out in time for our next session. Let's protect our children by keeping those offenders off the streets for a long, long time. And let's not victimize them again, the most vulnerable in our community. Again, Madam Speaker, our children. Thank you for having this hearing today, and I look forward to hearing the statements or testimonies on it. Thank you, Madam Speaker.
Thank you, Senator Ada. Now I'd like to call on Assistant Deputy AG of Prosecution David Rivera, or Deputy AG Stephanie Mendiola of the Division of General Counsel.
Thank you, Madam Speaker. I'll go ahead and present our testimony, or actually we're appearing in support of the bill. We did submit written testimony, but we weren't able to until this morning. Did you want us to read it into the record?
Yes, please do.
Sure. Okay. Hafaday Speaker Terlaje, thank you for the opportunity to provide testimony on Bill 8-36 COR. We support the intent of Bill 8 to treat criminal sexual conduct crimes, or CSC, more severely by prohibiting a court from departing from the mandatory minimum sentences identified for each crime, but we take no position on specific penalties. The Justice Safety Valve Act of 2013 grants the court discretion to depart from mandatory minimum sentences when it finds substantial and compelling reasons that imposition of a mandatory minimum sentence would result in substantial injustice to the defendant, and that the mandatory minimum sentence is not necessary for the protection of the public, citing 9 GCA subsection 80.39.1. In exercising its discretion, the court must consider the nature of the crime, the history and character of the defendant, and the defendant's chances of successful rehabilitation. Exempted from the Safety Valve Act are 3 situations where the court cannot impose a sentence below the mandatory minimum. 1, when the individual has a conviction for the same offense during the 10-year period prior to the commission of the offense. 2, when the individual intentionally uses a firearm in a manner that causes physical injury during the commission of the offense. Or 3, when the individual was the leader, manager, or supervisor of others in a continuing criminal enterprise. Bill 8 proposes to adopt a 4th exception for cases where an individual has been convicted of 1st or 2nd degree criminal sexual conduct. We support this proposal and offer for consideration minor changes to the phrasing of the proposed provision to read instead as subsection D, the individual is being sentenced for conviction of 1st or 2nd degree criminal sexual conduct as defined by 9 GCA subsections 25.15 and 25.20. Using the term individual is consistent with the language of the prior subsections, and specifying that the individual is being sentenced clarifies that the conviction to consider is the conviction in the case before the court at the time of sentencing. Thank you for your consideration. Sinceramente, signed, Liban T. Camacho, Attorney General. So in short, it just reiterates what sponsoring Senator Ada had said, is that the CSC, the more serious CSC crimes, 1st and 2nd degree conduct, are not currently exempted from the court's discretion, and we support the intent to do so. And the language that we proposed for the revision isn't substantive at all. It was just more to be more consistent with the language that the section will be, the proposed provision will be added to, is all. Thank you.
Thank you, Attorney Mendiola. What is the effect of changing Chapter 25 of Title IX to specifically naming 25.15 and 25.20?
Sure. There should not be any effect on doing so because the bill is written, specified that it is intended to target 1st or 2nd degree CSC as defined in Chapter 25. All we did was just replace the specific subsections of the actual definitions. So instead of just saying as defined by Chapter 25, we just specified the actual definition subsection. So for 1st degree CSC, it's defined in 2515, and then correspondingly 2nd degree CSC is defined in 2520. That was all. So it's not intended for any substantive change.
Okay, thank you. And so this, by making this an exception, we are now removing the judge's discretion to determine if the imposition of the mandatory minimum sentence would result in substantial injustice to the defendant. Do you, what types of cases have judges found that there would result a substantial injustice to the defendant and that they needed to reduce the sentence? For criminal sexual conduct cases, have you ever seen that?
Sorry, Madam Speaker, one moment.
Speaker, I have not specifically observed the situation that you described. However, I had some discussions with my colleagues concerning the situation that we refer to here in the office as Jack and Jill criminal sexual conducts. And that's a reference where two young individuals, both close in age to minority, one below the age of minority and one just a couple of years above the age of minority. And often the precipitating factor behind charges is not the participants, because we find situations where a child under the age of 14 or under the age of 16 has at times engaged in consensual sexual conduct with a person who's slightly older, but over the age of 16, say. And so technically that person over the age of 16 can be facing a first or second degree felony, depending on the conduct. And it's often the parents behind the younger child who's a precipitating factor in trying to see charges go forward because of the potential embarrassment. Or one situation I saw where the parents seem to have been supporting the two children, change their position when they felt like the man wasn't behaving as he should as someone who would be supporting a child, because the younger minor had been pregnant, but they still had a relationship together. So because of the certain unusual circumstances that occur when you get around that borderline threshold and people really close in age, there could be a sense of injustice at times when you have the older individual who himself could be still very young. We're not talking about the situation of sexual predators who are out there who intentionally target minor victims and engage in these conducts with them. And unfortunately, the minor children often can't exercise their discretion properly, which is what the statute recognizes. But we do at times recognize that sometimes there are situations between young people who engage themselves in relationships, and maybe more than they should have. But is it something that we're going to send them to jail for 25 years or some really long period of time? And in the past, how we've tried to deal with that is to offer a reduced plea sentence on a lesser level so that we can have some room. But even then, we always have the conundrum of dealing with, well, these are both two very young individuals. And in their minds, it's clear they just had a relationship going, and neither one really had the maturity at that point to really make good decisions. But one of them is potentially subject to being punished, potentially harshly, and the other one is seen as the victim because of the threshold on the other side of the line. So that's the one situation that I raise as a concern where we always should have a way to kind of look at that situation to see if it's fair and equitable. Obviously, if you have kids close in age, but one is actually forcibly raping another, we're going to push to the absolute limit. But it's that situation where they otherwise have what would be considered a boyfriend, girlfriend, or other partnership relationship, which is consensual on both sides. And unfortunately, they got caught, and now the justice system is going after them, snapping at their heels. And at that young age, we really want to submit them to the amount of time that they could be facing for, in effect, falling in love with someone else that's close to their age. So that's the main comment I wanted to make there, where I could see the possibility. But I personally haven't seen judges exercise any of the exemptions, although I don't normally, in my experience, I've dealt mostly with homicide cases and cases of severe assault and injury. And we have other attorneys who specialize and deal with CAC cases. Thank you for letting me add that, Speaker Terlaje.
Okay, thank you very much. So for the record, BBMR granted Bill 8-36 a fiscal note waiver as the proposed amendments are administrative in nature and would not physically impact appropriations for FY 2021. The Legal Bureau's comments were on preliminary review were only technical edits. And so now I'm going to ask the primary sponsor, Senator Adder, if he has any questions for the panel.
No, I don't, Madam Speaker. Thank you. I'll just continue to listen on to other testimonies.
All right. Senator Pedo Terlaje, do you have any questions for the panel?
No, Madam Speaker, thank you very much.
All right. Senator Duenas.
No, Madam Speaker, it looks like a thorough review. I just want to thank the author for introducing this important legislation.
Senator Taitigui.
Thank you, Madam Speaker, and thank you to those who are here today to testify. Madam Speaker, I'm looking on the Google Drive to try and find the testimony of the Attorney General's office. Was it placed on the Google Drive? If not, then I kindly ask that they send us a copy. Send us a copy of their testimony.
We will provide it. We did not receive it prior to the hearing, we think. So
Okay, thank you so much. Thank you so much. I appreciate it. Thank you.
Okay, there being no other questions or testimony, I would invite the sponsor to close on the bill.
Thank you, Madam Speaker. Madam Speaker, Madam Chair, I also would like to thank the AG's office for their recommendation and testimony on Bill 8-36. And Madam Speaker, I would also like to exempt the safety valve treatment from Section 80.73.3 of 9 GCA, which is the Vulnerable Victims Sentencing Enhancement Act. And this sentencing would also be excluded for first or second degree criminal sexual conduct. And, we can do these things as we do the markup on Bill 8-36. And again, Madam Speaker, I humbly ask that, this be reported out for our next session in March. And I look forward to everyone's support. Thank you, Madam Speaker.
Thank you. With that suggestion, I'd like to bring it back to the Attorney General's office. Have you looked at that at all, or should that be a separate bill?
I hadn't yet, Madam Speaker. I was actually trying to pull up the citation as Senator Addo was referencing it, but we can take a look at it, and if it has any impact on our testimony, we can certainly let you in the committee know.
All right, thank you very much. Senator Torres, would you like to ask the panel any questions of the Attorney General?
Thank you, Madam Chair. No,
All right,
thank you.
All right, so that will conclude the public hearing for Bill number 8-36, and we will move on now to the second item on our agenda, which is Bill number 45-36 COR, introduced by Jose Pedo Terlaje, Tina Rose Muña Barnes. An act to amend 9 GCA sections 25.15 and 25.20 and add a new section C to 9 GCA 25.25 to address mandatory minimum sentences for repeat sexual offenders. I would invite Senator Jose Pedo Terlaje to introduce the bill.
Thank you very much, Madam Chair, for allowing me to speak on the bill 4536. And I just want to thank the Attorney General staff and everybody that's present here today. Madam Chair, this bill was written in collaboration with the Attorney General's office and was designed to provide a stopgap in the law. While we have minimum mandatory sentences for crimes such as armed robbery, burglary, and other similar crimes, there are no mandatory minimum sentences for sexual crimes. We all realize that more has to be done in regards to protecting our most vulnerable, our children and the woman, and everybody else. And so the AG's office and together we are seeking to revamp our sexual assault laws to ensure that prison sentences are just and provide the victim with some form of justice. The mandatory sentences will provide our AG's office with an additional tool in the prosecution of sex crimes. And I ask all of you to support this measure and look forward to all the testimonies so we can ensure the best measures is put into code so we can protect our women and children, and hope that this mandatory minimum sentences will act as a deterrent to future sexual assault crimes. And I want to thank you, Madam Chair, for the invite. Thank you very much.
Thank you very much, Senator Terlaje. I'm going to recognize again for the record that present with us are, of course, the sponsor of the bill, Senator Jose Pedo Terlaje, Senator Anthony Ada, Senator Chris Dueñas, Senator Taitagui, Senator Mary Torres. And I'll now recognize the Attorney General's office to submit testimony. If you could just again identify yourself for the record, please.
Of course, Madam Speaker, thank you. For the record, I am Deputy AG Stephanie Mendiola of the Division of General Counsel, and with me is Assistant Deputy AG David Rivera of the Prosecution Division. We are here again in support of the measure, Bill 45, and we had submitted written testimony this morning per permission of your office. We've uploaded a copy into the Zoom chat for everybody's reference, and I'm assuming again you would like us to read it into the record. Yes. Okay.
Yes, please.
Okay. So what I will say first is that this, for easy reference for you and your committee members and members of the body, we included a chart. So I'll just read across the chart when we get to that page. Hafiz Speaker Terlaje, thank you for the opportunity to provide testimony on Bill 45-36 COR. As expressed in our testimony on Bill 8-36, our office does not take positions on what specific penalties should be imposed. However, we strongly support the intent of Bill 45 to treat criminal sexual conduct crimes more severely by enhancing the punishment for repeat offenders. For easy reference, we provide the following chart of the relevant sentencing ranges. For first-degree CSC, it is classified as a first-degree felony. The current sentencing range for a first offender is 15 years to life. The current sentencing range for a repeat offender is 25 years to life, only if the prior conviction is for first-degree CSC. As the bill proposes, the sentencing range for a repeat offender would be 25 years to life for any prior CSC. For second-degree CSC, the classification is a first-degree felony. The current sentencing range is 5 to 20 years. The current for a first offender, for a repeat offender, it's 25 years to life. Again, only if the prior conviction is for first-degree CSC. The proposed sentencing range in the bill is 15 years to life for any prior CSC conviction. Third-degree CSC is currently classified as a second-degree felony with the first offender range of 1 to 8 years. For repeat offenders, it's 3 to 10 years. If the person is convicted of a prior felony, not necessarily specific to CSC, and under the proposed bill, the sentencing range for a repeat offender would be a minimum of 10 years for any prior CSC. We'll come back to a notation on that in a minute. For fourth-degree CSC, it has two classifications. If the person is a first offender, the classification is a misdemeanor. If they are a repeat fourth-degree CSC offender, the classification rises to a third-degree felony. The current sentencing range, of course, for the misdemeanor is 0 to 1 years, and for a first offender, third-degree felon, it would be 0 to 3. The current sentencing range for a repeat offender for third degree is 0 to 5 years, and a repeat offender sentencing range is not proposed to be enhanced by this bill. So the most significant change is that the increased penalties would be applicable to a conviction for any prior CSC offense, not just first-degree CSC. We note 2 points for your consideration. And if I could just sidebar for a moment, the asterisks near the numbers reflect the asterisks within the chart. So the first point for consideration is referring to row 3, column 3, the 5 to 20 years. First, section 2, page 4, lines 17 to 18 appears to be missing a phrase that is included in the current law. After the phrase, open quote, nor shall parole be granted, close quote, the punctuation should be a semicolon in place of a period. and the sentence should continue to read, open quote, nor shall the provisions under subsection 80.31 of Article 2, Chapter 80, Title 9, GCA apply, period, close quote. This missing language operates to establish a sentencing range for second-degree CSC of 5 to 20 years imprisonment. If the language was intentionally excluded, we highlight that such an amendment would reduce the second-degree CSC sentencing range to 3 to 15 years imprisonment. The second set of asterisks is referring to the row for third-degree CSC, the last column on the proposed sentencing range, that being the minimum 10 years. Section 3 on third-degree CSC, page 5, line 21, proposes that a repeat offender, open quote, shall be sentenced to a minimum of 10 years, close quote. Because a 10-year sentence is also the maximum sentence for a second-degree felony, the language should read, open quote, shall be sentenced to 10 years, close quote. Thank you for the opportunity to provide testimony on this measure. We look forward to passage of this bill. Sinceramente, signed, Cleveland T. Camacho, Attorney General. So again, in a similar position, we definitely defer to the legislature on what the specific penalties would be, but we support the sentencing enhancements for repeat offenders, and we're happy to answer any questions to clarify, because our testimony today is a little bit technical. Thank you.
Thank you very much. I want to note for the record that the fiscal note per BBMR granted a fiscal note waiver as the proposed amendments are administrative in nature and would not fiscally impact appropriations for FY 2021. The Legal Bureau offered technical and stylistic recommendations, and in addition, they recommended confirming the legislative intent of the bill as to 9 GCA 25.20C, which, if enacted, appears identical to the proposed new section added 9 GCA 25.25C, except for what would be conflict sentence terms. I would ask the AGs if they could take a look at that, and then can you just tell us if the like how we are treating repeat sex offenders? Is it because we're changing the definition of repeat sex offenders, because there were enhanced penalties prior to this for repeat sex offenders, isn't that correct?
Yes.
Okay, and so is this for the first time including off other jurisdiction offenders? This is the first time in our statutes that we will be doing that? I mean, for this crime?
I'm not entirely sure. Do you know if it's the first time? It's because it's the other jurisdiction crimes are defined in the are addressed in the other section of Chapter 8.
Right, Speaker Terlaje, this is David Rivera, Assistant Deputy Attorney General. Specifically as relates to the CSC provisions, which fell upon the commission of a violation and defined it under Guam Code. And so now, to my observation, the definition included the expansion within the code itself to CSC type offense that would fit under the Guam definition. And so as the proposal is written, I don't think we have to look outside the statute to other definitions to say that an outside potential similar crime could apply, because it's unambiguously put within the, or if passed, would be put within the criminal sexual conduct provisions as the part of the amendment.
All right. How many CSC convictions have defendants, do we know of, that the defendants have been accused or convicted of a CSC in another jurisdictions, for example? Does this happen often?
I'm not sure. I don't know if we can get the answer for you on that.
Yeah, we'd have to research that.
Are the judges informed then? How are the judges informed of whether there is a conviction in another jurisdiction? Is that from the registry or how?
If I may, Your Honor, Assistant Deputy Attorney General David Berrigan, I believe the burden would normally be on our office because, you know, we're the ones advocating for the sentence. And so, you know, we would hopefully be able to, in our research during the pendency of the case, if we're able to learn that there are outside convictions, and that would normally involve a little additional work because we normally have to do an NCIC check, which is a more national database where criminal conduct is entered, as opposed to the rap sheets that are submitted, which come to the Guam Police Department, which pretty much reports what we have locally. Sometimes we're aided by probation, which sometimes they pick up on it and they let us know. But if we learn of it, then we would normally advocate that such a situation fits within. That's if the law allows it. Under the CSC, as I said, I don't normally do civil criminal sexual conduct cases. So I don't know to what extent, if any, that's been attempted to be advocated before. But again, since the original statute, which is being amended, appeared to refer only to criminal sexual conduct prior convictions here on Guam, I don't know to what extent it might have been relevant to refer, except to the extent that a judge sentencing within the allowable guideline range could exercise his or her honor's judgment to go to the higher end of the sentencing if they're aware of similar conduct in other jurisdictions, although they may not necessarily be able to enhance it. Now, however, I believe the amendments will allow it to additionally enhance the sentencing.
All right. All right, thank you. I would now like to ask the sponsor of the bill, Senator Pedo Terlaje, if he has any questions for the panel.
Madam Chair, I just want to say, and I want to thank Ms. Mendiola for her testimony. And actually, the things that she had mentioned was clearly enunciated on the bill. But I know there's some things that she brought up that probably needs to, I need to get the testimony and maybe refine the bill. And maybe it can invigorate some of the things that she talked about that is missing on the bill. So that's all that I want to ask Ms. Mendiola to give me a copy of her testimony, because I know there's mentioning that is not within the bill, and I want to make clear that the bill is complete and refined, and so that everybody understands. Thank you, Madam Chair.
Thank you, Senator. Senator Abbott?
I have no questions, Madam Chair, but I'd just like to thank the sponsor for the introduction of Bill 4536. Thank you, Madam Chair.
Thank you. Senator Duenas, you're recognized.
Yeah, once again, Madam Speaker, just to once again thank the author as well, and the AG's office for a thorough review and support of the bill. And I look forward to the markup by the author. Thank you.
Thank you. Senator Torres, you are recognized.
Thank you. I wanted to ask the AG's office, Stephanie, what of the criminal sexual, or of all the criminal cases and people who are incarcerated, what percentage of that is attributable to criminal sexual conduct? I'm just wondering proportionately how many of the convictions are of a criminal sexual nature.
I'm sorry, Senator, again, we don't have that answer. For those of you who may know, our lead on CSC cases is AAG Christine Tenorio, who is in court this morning. So I'm going to inform her that she has her homework cut out for her to get you guys some of the answers on this. But while I can't say what the specific percentage is of the total conviction, CSC is regularly among the highest, at least for the last 5 years. I'd venture to say 10, but it's among the higher cases charged year over year. But we can, I believe we do have that data, and we can get that to you.
Thank you. I just noted that that this is a measure that the Attorney General's office is very interested in seeing through, as I understand. And what my sensitivity to this is whether the circumstances on our island mandate that we have to take these types of measures. And that's what I'm getting from your testimony, which is consistent, correct? Yeah.
Yes.
Okay. Yeah, unfortunately, I remember another presentation where it was discussed how domestic violence is the predominant offense on Guam. Domestic violence issues tends to be what dominates the cases in the court system. And, we should hope that we can stymie the criminal sexual cases and somehow reduce that by these types of measures. So I just want to also thank the sponsor for bringing this forward. Definitely is a measure that we will support on the floor. And I appreciate your testimony. Sizus Maasi.
Thank you, Senator. To the Attorney General's office, can you just be, sorry if this is repetitive, but can you just be very clear? So without this bill, are you able to take into consideration that it is a second offense or a repeat offense when you are asking for sentencing?
We can take into consideration that it is a repeat offense, but only for a repeat offense of a first degree CS, a prior conviction of first degree CSE. So this expands it for any prior CSE conviction. And then to tie it into your earlier question, I will confirm if that is limited or expanded relative to convictions outside of Guam.
Okay. All right. Well, thank you very much. Senator Terlaje, would you like to ask any more questions of the panel?
Madam Chair, I just want to thank you, and I want to thank everybody for being with us this morning. And I just want to tell the Attorney General that the testimony is going to help me to refine the bill. And I know there's several markups that I need to do, reference Ms. Mendiola's testimony, and I want to thank everybody. My colleague, thank you very much, and I ask that we support this bill for the good of our community. Thank you very much, Madam Chair.
Thank you, Senator. So just for the record, we received a message during the hearing from the Public Defender's Office who says they will be submitting written testimony, but they could not make it this morning. All right, and so we will provide that to the senators who are here today. All right, there being no additional individuals to present testimony, we will consider this bill 45-36 duly heard. The time is 9:42 a.m. We move on to the third item on our agenda, is bill number 44-36 COR, introduced by Jose Pedo Terlaje, Tina Rose Muña Barnes, Mary Camacho Torres. An act to amend subsection B of 60.80, Chapter 60, Title 8 of the Guam Code Annotated, relative to prohibiting plea deals without reasonable proof of victim notification. All right, we will now hear from the sponsor to introduce the bill. Senator Jose Pedo Terlaje.
Thank you again, Madam Chair, for the opportunity to speak on Bill 4436, or basically to require that victims of any crime are notified prior to approving any plea agreement regarding their case. Well, I understand that there is a requirement to notify victims. Far too many victims of crimes have not been notified of plea agreements and feel violated against because they found out that their violators has been plead down to a misdemeanor or even lower, and was not given their freedom to be part of the deal. And I understand that our AG's office may have its reservation on this bill and how to effectively address those concerns, and I'm willing to work with them on devising a better strategy to contact as many victims as possible on the pleas. This, Madam Chair, is an attempt to protect the rights of our victims and not slide towards the court or the Attorney General. And I ask that my colleagues for their support and assistance in ensuring in ensuring the rights of the victims. And I want to thank you again, Madam, and I want to thank the panel. And I'll listen to the testimony, especially with the Attorney General's office.
Thank you, Senator Terlaje. I'd like to acknowledge for the record at this part of our agenda, present with us are, of course, the sponsor of the bill, Senator Jose Pedo Terlaje, Senator Anthony Ada, Senator Christopher Duenas, Senator Mary Torres, and Senator Joanne Brown. Thank you, Senators, again for being here this morning. So we will now hear from the Attorney General's office. Please identify yourself for the record. Thank you.
Half a day, Madam Speaker, members of the committee, and members of the body. Again, for the record, I am Deputy AG Stephanie Mendiola of the General Counsel Division, here with Assistant Deputy AG David Rivera of the Prosecution Division. As much as we appreciate how smooth the public hearing has been going this morning, I suppose it's not truly a complete public hearing if there isn't a little bit of additional discourse between the legislature and the AG's office on the proposed measure. This is a bit of a hybrid. We are certainly in support of victims' notification efforts, and we honor and recognize the rights of victims that, as the sponsoring senator mentioned, already exist in the law under the Victims' Bill of Rights. But the concern is that we want to raise to your attention some of the potential we assume unintended consequences of what the proposed measure would be by prohibiting a court from being able to accept a plea agreement. Again, we were able to submit written testimony, but not until this morning. So we have uploaded it into the Zoom chat and we can read it into the record.
Yes, please do. Thank you.
Half-a-day Speaker Terlaje, thank you for the opportunity to provide testimony on Bill 44-36 COR. Our office is committed to providing victim input, victim notification, and victim services. The Victims' Bill of Rights, established by the Crime Victims' Rights Act of 2007 of 8 GCA Chapter 160, currently provides extensive provisions regarding victim notification and input relating to proposed plea offers and the court's acceptance of plea agreements. Victims or their surviving immediate family members have the right to be notified of any potential plea agreement and to express their views on proposed plea agreements prior to a plea agreement being reached between the prosecutor and the defendant. The prosecutor shall consider the views of the victim or the surviving immediate family members in deciding whether to negotiate or conclude a plea agreement with the defendant. Victims or their surviving immediate family members have the right to be notified when a plea agreement is to be presented to the court and to express their views on the plea agreement to the court prior to the court accepting or rejecting the plea agreement. The court shall consider the views of the victim or the surviving immediate family members in deciding whether to accept or reject the negotiated plea agreement. Before a plea agreement is allowed in any aggravated murder case.
I'm sorry, Stephanie, can you just go back a couple lines and start again? Just a couple, maybe a couple, 3 sentences. There was some.
Sure. No problem. I was starting at C. I'll just go back to B. Victims or their surviving immediate family members have the right to be notified when a plea agreement is to be presented to the court and to express their views on the plea agreement to the court prior to the court accepting or rejecting the plea agreement. The court shall consider the views of the victim or the surviving immediate family members in deciding whether to accept or reject the negotiated plea agreement. Before a plea agreement is allowed in any aggravated murder case where a defendant has or is alleged to have, with the premeditated intent, cause the death of another person, cause the death of such person or of a third person, and there was more than one victim, the murders were part of a common scheme or plan, or the result of a single act of the defendant, a prosecutor shall explain to victims or their surviving immediate family members of the case, the rights of the victims, explain to victims or their surviving immediate family members of the case how the plea agreement process works and the circumstances that might lead to a plea agreement, explain to victims or their surviving immediate family members of the case how victim advocates can help victims prepare and submit impact statements that are useful to both the prosecutor and the court throughout the plea agreement process, ensure victims or their surviving immediate family members are notified of any potential plea agreement and have the opportunity to express their views on any proposed plea agreements prior to any plea agreement being reached with the defendant, and ensure victims or their surviving immediate family members are notified when a plea agreement is to be presented to the court and have the opportunity to express their view on the plea agreement to the court prior to the court accepting the plea agreement. The citation for this is 8 GCA subsection 160.95, plea agreement provisions for victims. In every single case involving a plea agreement, the court and the government engage in a colloquy in which the court requires the government to confirm that the affected victim has been contacted, consulted, and advised as required by law. Each year, our office provides services to more than 1,200 victims. Unfortunately, there are cases where even after the exercise of due diligence, our office is unable to establish contact with the victim. Some reasons or phone numbers are no longer valid, or victims use prepaid phones and have no minutes. Sometimes victims have moved off island or out of the country. And in some cases, victims choose not to be involved. Where a victim has not been contacted, the court requires the government to provide documented efforts of exercising due diligence in attempting contact, including the number of times the victim is called or emailed, the date and time of phone calls and emails, the number of field visits made, and the outcome of those visits. The Victims' Bill of Rights recognizes that the court is responsible to issue all decisions and orders to enhance the recognition of victims' rights to the extent that they will not conflict with the constitutional rights of the defendant. That citation is 8 GCA subsection 160.60. However, in recognition of the fact that the practical realities may impede the ability for all these statutory rights to be addressed, the law also provides that a failure of the court or prosecutor to comply with the provisions of the Victims' Bill of Rights shall not be ground for appeal or for reconsideration by the court. And that's in 8 GCA subsection 160.80. While the bill is well intended and aimed at supporting victims' rights, as written, the consequences that the court and the government would be prohibited from resolving cases involving an unreachable victim. If a court is prohibited from accepting a plea agreement in cases where the victim is unreachable, despite the due diligence of the government will either be forced into trial with the weak case, or more likely will be forced into dismissing the case. Forcing a trial without a victim risks violation of a defendant's constitutional right to confront his or her accuser and risks prosecuting a case with weak evidence. Contrary to the intent of the Victims' Bill of Rights, these outcomes indirectly benefit a defendant and risk greater harm to our community. While we recognize the legislature's prerogative to regulate plea bargaining, we caution against such a restrictive measure and strongly urge consideration of these unintended consequences. Thank you for the opportunity to provide testimony on this measure. Sincere mentee, signed Leven T. Camacho, Attorney General.
Thank you very much to the Attorney General's office for your testimony this morning. I want to add to the record a BBMR's comment that I'm quoting, based on comments received from the Office of the Attorney General, victim notification of plea offers, notice of change of plea hearings, and the right to attend change of plea hearings are already required by law. The OAG believes that if the bill is an attempt to expand current requirements, there will be a need for additional human resources on their part, i.e., victim advocates, investigators, etc., particularly for added support when there is a great difficulty in securing the location or participation of victims. The OAG further comments that the fiscal impact of this bill, should it become enacted, would be the anticipated need for at least 2 additional advocates at a cost of $44,231 parentheses salaries and benefits per advocate, or $88,462 total. The Legal Bureau's comments on preliminary review were technical and stylistic only. I'd like to ask the sponsor of the bill if he has any questions, Senator Pedo Terlaje.
Madam Chair, thank you again, and I want to thank the AG's office for their presentation. And you know, the key word here is victim notification, and I think 4436 kind of just come out, and it does. The testimony that was provided by Ms. Mendiola or Tiffany really satisfy what we expecting as far as victim notification. There's other issues in this bill that was raised by Ms. Mendiola, and we will try to solidify whatever they're asking for, either place an addendum or exclusion on some of the language of this bill. And I just want to thank her for her input. And I'm pretty sure that once we get the testimony, we can refine this bill and take away what is the concern of the AG's office, because I heard that financing it is a big issue on this one. So I just want to thank you, Madam Chair, and we will refine this bill in a way that will satisfy both parties, the victim and also the Attorney General's office. Thank you very much.
Thank you, Senator Pedo. If I could ask the AG's office, there's in the Crime Victims' Rights Act, a penalty for violation. Has this penalty ever been invoked to your knowledge?
I'm not sure.
Madam Speaker, Assistant Deputy David Rivera. I'm not aware of the penalty being invoked, but I am aware of the ire of the court being cast in our direction when the court hasn't been satisfied with the measures to contact victims. And there have been some cases where the court has continued a case on more than one occasion to continue our efforts to try to contact the victim until such time that we can say that there is nothing more that we can do. So the judges certainly, in my view, attempt to enforce it. They always begin by asking, has the victim been notified? Is the victim present? And if the victim hasn't been notified, the court will want to know what the issues are. And I've frequently seen the court continue a case and direct our office to continue further efforts to try to locate the victim, make contact, and so that we can proceed in the case. But as far as a penalty imposed, I have not seen that. But you know, I will say there was a period of time for about 5 years I was Solicitor's Division before returning back to prosecutors, and during that time, I'm not aware of a lot of what was happening in prosecution. So possibly during that time, but my knowledge is no, I'm not aware of it.
All right. I agree with the sponsor that despite the law in existence already, despite the mandate, despite the fines that are for penalties of violation of the law, and despite the ire of the court, we continue to hear from victims that, who say they have not been notified. And so, of course, we just want to see if there's any other ways to improve this process. Last year, the Office of the Attorney General started using the Guam Victim Information Notification Every Day, the VINE electronic notification system. Does that system include notification for plea deals or plea deal hearings?
It does. It would include the notification for the hearing, yes, because it's the hearings and the movement of defendants. It would be what is it would notify of what is an official event. So the in-between for the negotiations between the parties, the prosecution and defense counsel, it does not notify about that. But what I will say is that during this process, the victims our office works closely with the victims, especially in more serious cases, right? The victim of a murder, or as we've been talking about this morning, CSC versus the victim of a robbery, etc. So to answer your question, VINE would notify of the hearings involving the plea agreements, because those are the official events within the system, but not specifically regarding any meetings or what have you about the plea agreement in between hearings.
Right now, the Attorney General's office informs the court verbally. Is that correct? There's nothing in writing that says we have been unable to notify the victim for these reasons, or that we have notified the victim. It's just a verbal representation during a hearing.
Yes.
All right. What do you think about putting a written requirement that the AG's office present in writing along with a plea agreement, whether the victim has been notified or prior to, so that has to be submitted to the court?
Yes. The efforts of the office already have to be documented. So if that's going to be a requirement, I don't see it being an issue. And just to clarify from a bigger picture perspective, that's sort of what we were getting at with our testimony, is that we're not opposed to efforts to try to improve the process. By no means are we trying to take the position that we are 100% effective at notifying victims. But the way that the system is currently set up, our office together with the court work in tandem to make sure that victims are contacted. And so if it is a matter of the legislature wanting to see what the efforts are, if it's the legislature wanting to set a baseline for what's considered due diligence, if it's you know, just adopting something that will satisfy what showing the government makes, then that would still allow cases to proceed to resolution without such a stringent restriction.
All right, thank you. I'll now call on Senator Ada. Do you have any questions for the panel?
Madam Chair, Madam Speaker, I have no questions. I just like to thank the Attorney General's office for coming out for their, and I'm testifying on both, all three bills, matter of fact, 845 and 4436. And then I just also wanted to make a correction on the section that I stated. It was the Vulnerable Victims Sentencing Act, section 80.37.3 of 9 GCA, and it's not 7.3. So I just wanted to make that correction so that they'd be able to know that that's what I was looking at. Thank you, Madam Speaker. Thank you to the AG's office and to my colleagues.
Thank you, Senator Ada. Senator Duenas, you're recognized.
No questions, Madam Speaker, but I think it's clear in the intent that the sponsors and the legislature are very concerned, as you said. You know, whenever we get a notification, you know, that a victim felt as though that they weren't not informed. So I think the AG's office is extremely sincere about this effort, and I look forward to the authors, you know, working with the AG's office on the bill or on some other satisfactory resolutions. But Sidusmasi, and once again, we wish the AG's office all the best on their efforts, and I want to believe that they're sincere in making sure that victims are taken care of. So thank you very much.
Thank you, Senator Duenas. Senator Torres, you're recognized.
Thank you. I want to express my appreciation to the AG's office for inviting us to look at the bigger picture and for pointing out the unintended consequences of what was really a well-intentioned bill with this bill. So I look forward to looking at your analysis and, you know, looking further at the statute and arriving at what really was a way to help victims further. Because as the speaker mentioned, you know, there is an expressed concern that many of us took to heart when we signed on to this bill. And so it's just now a matter of mediating that and finding where that reasonable ground is, if really there's a need to improve upon the existing statute. But the bigger picture, I think, was the operative word here, and I appreciate that and look forward to working with the main sponsor.
Senator Torres, you were muted towards the end. You look forward to working with the main sponsor.
Okay, I just said I look forward to working with the main sponsor to finding what would be the medium, what would be the happy marry to arrive at what we had intended with this bill. And again, Sizusmasi. Thank you.
Senator Brown, you're recognized.
Thank you very much, Madam Speaker. I did want to ask the AG's office. I mean, obviously, I think we all are very supportive of the intent of wanting to ensure that victims of crime in our community are notified as you know, their cases go through the legal process, and you know, the hope that those that have violated them are being properly addressed through the judicial system. But you know, the AG's office relayed that they already, through the current victims requirement, are doing this. So if I can ask them, where do they think there's a disconnect? I understand, you know, individuals may have moved, they may, you know, have changed their contact number and not provided it to Attorney General's office for further follow-up, but where do they think, is there a gap, and where can it be improved so we don't end up in a situation where, because a victim cannot be contacted, a case gets thrown out because they're not consulted? So can they enlighten us perhaps where there's gaps as to why, there's this slight disconnect that some victims are claiming they were never notified, and yet, agreements were moved forward. Where do they see the gap in their own experience coming out that would cause a concern to the level of having a bill such as this generated?
Sure. I'm not sure how we would address the gap, because I'm sure the concern that comes to the senators and that's expressed to the community when victims are not notified are exactly that. But in looking at the total amount of cases, more victims are notified than not. The gap that we face operationally in contacting victims is, as what we noted, is just with contact information or not wanting to be involved. And I think just, as like I was mentioning earlier, no government program works 100% or 110% effectively, right? So we have the different mechanisms to try to balance it out. And the other half of our office notifying victims of their rights and of the progress of their cases is also providing the mechanism for victims to contact our office and victims to have a hotline that they can always reach out to us. So I'm not sure, I don't know how to address what a proposal would be to fill the gap, so to speak, but just to satisfy the concern that the efforts of our office are in fact being made as required by law. I would agree with Speaker Terlaje that maybe it's just a matter of providing that and putting that on the record. I mean, what we were getting at, and I was trying to pull up the fiscal notice, as Speaker Terlaje mentioned. Even for our office to take the position that 2 additional advocates would help, I'm not sure that any government program, you give it enough staff and it'll reach 100 or 110% accuracy. It's just more so that if our current baseline with our current resources is to reach out to our victims, maybe 3 phone calls over a period of 3 weeks. If you have additional support, you can do 5 phone calls over a period of 5 weeks, or certain things like that. But I'm sorry, Senator Brown, I guess to what we would recommend to address this specific gap is, we don't have a specific recommendation, but just more so to allow both our office and the court to establish what the efforts have been and still get to resolution of a case to hold a defendant accountable, even in a circumstance where a victim is unreachable.
Is it common? I mean, you mentioned, I know you outlined some of the things. Is it maybe like their phone number changed, or what is the common reason you're finding on those cases that you're not able to connect with the victim? It could be over time, as you mentioned, and maybe the reality for some, they just don't want to deal with it anymore. Maybe they've moved on in their lives and they want to have to go regurgitate and relive maybe a very traumatic experience. But what are you finding are the main reasons perhaps why your office is not able to contact the victim to be able to discuss this, their cases further with them?
Yes, that part we could definitely speak to, and you're right on the money. It really is just the phone call, the contact information. A lot of the victim population that we support use prepaid phones, and their phones run out of minutes. Our victims advocates have gone so far as, over the years, we've used even web-based texting. Docomo used to have a feature on their website where you can send text messages through the web to phones. And even if they didn't have minutes, the text message would still be able to go through. So you leave a message to call back. That was actually pretty effective for our advocates. That's no longer available. But what the bittersweet part of the pandemic, right, is it really pushed technology to the forefront. And Even sooner though than 2020, what the advocates have been doing over the past several years is also adding the email element and asking victims for email addresses. I think the effort really started maybe around 2017 or so, to send email notifications. And if I could just clarify, because Speaker Terlaje brought up the issue of Vine, while we have adopted the Vine system, please know that that does not, the ability for victims to receive auto notifications through the Vine system does not substitute our efforts in no way. So we don't say, okay, we see this victim. First of all, the system's anonymous, but even if we were to know this victim signed up for auto notifications, that does not then tell us, okay, we don't need to notify them. So I just wanted to clarify that as well. But yes, the number one issue is just contact information with phone numbers. And as Ada Rivera mentioned, that's where we make the efforts through phone, make the efforts through email, and then of course go out to take it to the next level and go out and do field visits to their homes.
My last question, I mean, aside from the Vine system, is a victim able to call and talk to another human being at the AG's office to, one-on-one be able to follow up on their case, even without it going to court yet, but just, I haven't heard, anything in 2 years. What's the status of my case? Because I think some people want that comfort of, having a human being on the other end of the phone to talk to, especially these are all, I'm sure every single case that it's before you, it's an unfortunate situation that happened to that individual. So are they notified at the time when they're going through the process and they file a complaint, or somebody gets arrested on, because they violated something with this individual, the victim's given, the contact information, how they can track, who they can interact with in the future if they need, to call in? Are they all provided with that process?
Yes.
And do they know who they can call at the AG's office to talk to?
Yes, you're exactly right, which ties into what I was mentioning earlier is, in terms of addressing the gap, it might just be finding ways to better evidence efforts, but it's both our office that is responsible for the outreach and, exactly as you mentioned, notifying victims of how they can contact our office. We have a general victim hotline that is available to them, but our victim advocates are also assigned to case types. So the victim will know who their advocate is and who to reach out to, and it's not going to change on Monday to Tuesday to Wednesday to Thursday.
I see. Well, thank you very much. I appreciate you responding to the question. Certainly gives me, and I'm sure other colleagues, greater insight into some of the challenges and the efforts also that you're putting forth to notify victims in our community that have been adversely affected by these unfortunate circumstances. So thank you very much. And certainly thank you, Madam Speaker, for the opportunity to ask these questions.
Thank you.
Very much, Senator Brown. Senator Jose Pedo Terlaje, you may close on the bill.
Thank you, Madam Chair, again. I just want to say that there's no way that we can go out there and disrupt the efforts of the Attorney General's office to do the prosecution to whatever. And as I understand, with all the testimony that is being presented, the major impediments of prosecuting some of these cases is, one, the finding the victim, and the other one is financial. So those are the two things that I'm considering in as far as really just coming down and looking over the bill and the testimony. And for sure, I want to thank Stephanie for such a complete report, testimony to us and all the panel. I want to thank you all for being here this morning, and I really appreciate the testimony and the questions that that we impart with the Attorney General's office. And I want to thank the speaker again, and we'll do everything we can to solidify whatever is needed to rectify some of the issues that kind of just maybe restrict the Attorney General's office from doing their job. And I want to thank you, Madam Speaker, and I want to thank the panel, the senators. Thank you very much.
Thank you very much, Senator Terlaje, and all the senators who've been here with us today. Thank you again to the Attorney General's office. I very much appreciate your testimony and you being here to answer questions. Very helpful. There being no further testimony, we will consider this bill number 44-36 duly heard. The time is 10:14 and this public hearing is now adjourned.